Hello, this is Matt on the Moon Lambeau channel. John Deaton, who is the lawyer who has filed a writ of mandamus, which is seeking to compel the Securities and Exchange Commission in the United States to amend their complaint against Ripple to remove verbiage of XRP being a security. He believes that the SEC may very well be just trying to force Ripple to settle. And so the way they're going about it, if so, is disgusting. Although I would not mind if there's a settlement, because if there's a settlement, Ripple's not going to do it if it's going to completely wreck their world. So what does that mean? Well, certainly they wouldn't move forward with that if part of this whole deal were that XRP were indeed a security. So there's probably something to this. So I've got a whole bunch of information from John Deaton. So he's again the one that's has filed the writ of mandamus. And if it comes to it, within the next 6 months roughly, he will, if necessary, he will be filing a class action lawsuit against the SEC for the damages that XRP holders have incurred as a result of the way that they've approached this whole thing. And it's insane to me, the complete disregard that the SEC has for the investor, which allegedly it's trying to, that you and me holding XRP, like allegedly that's who they're trying to protect. I don't know about you. I don't feel very protected by the SEC. I feel threatened by them, frankly. But I do want to be clear that I don't have any sort of law background whatsoever. Definitely not a lawyer. I do not have a financial background whatsoever. I am not offering financial advice, and you should not buy or sell anything because of anything that I say or write. I just think it's interesting to talk about these topics as an enthusiast, and I run this YouTube channel purely as a hobby, which is my most favoriteest hobby I've ever had, but that is all that it is. So let's kick this off. Stephen Bull Deep tweeted out the following. The reason why Bitcoin is falling. The SEC has sued all miners for selling the Bitcoin as unregistered securities to the public to fund their mining operations. Hashtag Bitcoin joke. Which I read that and I was like, yeah, that's a funny point. But John Deaton responded. Check this out. Lawyer John Deaton responded with the following. I invested money, factor one of Howey. So we're talking about the Howey test here, which is since, what was it, the mid-1940s? I can't remember the year. I think that's right, though. This test that has resulted from those court proceedings, it's how you determine if something is a security or not. And it's a four-pronged test, so that's what he's citing here. And so again, John Deaton wrote the following. I invested money, factor one of Howey, in a Bitcoin mining pool, i.e. common enterprise, factor two, with an expectation of profits, factor three, and I rely on the efforts of others, factor four. Do you see the danger, crypto community, Bitcoin maxis especially? Well, I'll tell you what, I sure as hell see the point that he's making there. And John Deaton, I saw him in an interview on the Chain Live, and he said he actually brought that point up then too. And he said, look, look, to be clear, I don't think Bitcoin is a security. He's just making a point that it's a slippery slope, and you start going down this path, and every cryptocurrency on the planet is now suddenly a security. It's dangerous. And then here's a tweet from Mr. Use Case on the Twitters. The IRS needs to F off with taxing crypto until they classify WTF XRP as who else agrees? Fair enough point. John Deaton happened to respond to this one too and wrote the following. I agree with your sentiment. I agree government in general is not the solution, but the problem. However, I agree with Raoul Paul when he points out that government involvement and regulation is inevitable before mass adoption. Unfortunately, the IRS will tax your profits. Be careful. Yeah, I know, and it's just disgusting because the various departments of the United States federal government can't really get on the same page as far as what cryptocurrencies are, so they're all just going at it and trying to regulate it, and something needs to be done on a congressional level. I'm just saying. So now, as far as the meat of this video here, which I'm getting into right now, this idea that the SEC is effectively overcharging to try and get Ripple to settle. Again, I'd love for them to settle, but this is check out the train of logic from John Deaton as I go through this, because it's just what they're doing. If you try and just apply logic, it doesn't work. Like, it's never going to make sense. If you try and think through, okay, Why logically would the SEC be doing what they're doing? And you read their complaint and all their reports. It doesn't make a lick of sense. It really does not. So at that point, what can you do but speculate as to the reason? Well, this is what he calls his kitchen sink approach. So check this out. Theory 3, the kitchen sink approach. The only logical explanation for why the SEC would allege that all of today's XRPs constitute securities is to force a settlement. It is an often common tactic for a prosecutor to overcharge a defendant in an effort to cause panic and fear. Federal and state criminal prosecutors do this all the time. For example, instead of charging someone with assault, they charge attempted murder. Instead of facing 2 to 5 years in prison, he now faces 25 to life. Even if the person truly believes he was acting in self-defense, the fear of what might happen is too much, so he accepts a plea bargain and does a year in prison. In civil prosecutions, like the SEC's case against Ripple and Brad Garlinghouse and Chris Larson, prosecutors sometimes do the same thing in an effort to try and force settlement. If the SEC wanted to hold these two executives liable, it could have done so separately by alleging specific distributions made by them personally at specific periods of time constituted by securities, but as I hopefully demonstrated in previous threads, XRP itself today is not a security. And let me just pause there for a moment. So it could very well be the case that they're trying to convince Ripple to settle, because look, I don't think that the XRP really wants to go to court and try and argue that XRP is a security. They're going to fall flat on their faces if they do that. But I was thinking about this fact also. Brad Garlinghouse has publicly stated that Ripple attempted to settle with the SEC, and so they weren't able to settle. So why would we think logically that the SEC wants to settle? I just think they're playing hardball. If this is the route that they're going, so the terms were not agreeable between the SEC and Ripple, and so now they're just amping it up and putting the pressure on. So it doesn't mean that the SEC doesn't want to settle. It means that they're getting tough. And still, and also don't forget this too, with an incoming administration here in the United States, the people in charge, it's changing. Already, of course, the day after this whole complaint was filed, chairman of the SEC, Jay Clayton, resigned the very next day. So things are changing, and I'm still very optimistic that this is going to get cleaned up in a way that's going to be agreeable to both parties. But anyway, let me continue with John Deaton's thread here now. According to the SEC complaint, the parties entered into statute of limitations tolling agreements. Therefore, the parties discussed a potential resolution or settlement. This is corroborated by Garlinghouse in his letter to Ripple employees when he stated that he and Larson could have settled separately but chose to fight the charges. Clearly, a pre-filing settlement was out of the question. Thus, the SEC possibly employed a kitchen sink approach to the charges and threw everything in, including the sink. And so, yeah, I'm not disputing what John Deaton wrote there is correct. But again, just to be clear, what I'm stating is that it wasn't going to happen. The settlement wasn't going to happen. But we do know that ultimately that they did attempt to find common ground. They were not able to find it. Right. And let me continue with the thread now. Simply put, the SEC filed the most aggressive complaint they possibly could in order to inflict the greatest harm they could in order to bully or coerce a settlement. I offer the kitchen sink theory because there is no possible way that the bright and talented lawyers at the SEC honestly believe that they can convince a judge or a jury that all of today's XRP in existence in thousands of accounts of investors that have absolutely no connection to Ripple or its executives are all securities. The claim that today's XRP, the XRP sitting in the accounts and or digital wallets of all XRP holders, constitute securities under the Howey test is so weak that I don't believe an SEC prosecutor will go on record acting in good faith and argue that claim. They can certainly argue that XRP was a security in the earlier years. Remember, the SEC Commissioner William Hinman argued that ETH started off as a security, but by 2018, ETH was no longer a security. Huge difference. I see no difference between XRP and ETH as it applies to U.S. securities law. But it's not just John Deaton that says so. Former SEC Chief Joseph Grunfest says so. Former CFTC chairman Giancarlo, also in charge of the Digital Dollar Project, says so. Quite frankly, it would be legally incorrect, intellectually dishonest, and completely disingenuous for any SEC lawyer to stand up in open court and claim that all of today's XRPs are securities. If the SEC attempted to make that argument, it would be laughable if the economic damage that has been done wasn't so tragic. Well stated. John Deaton absolutely killing it again and again and again. And so there's another thread here. And I look, like I said, I'm not a lawyer, so I don't pretend to know anything. That's why I'm just trying to listen to as many lawyers as I can, and I really am. And so there's John Deaton. There's Jesse Hines, who I've highlighted on the channel before. And they're working, well, Jesse Hines has offered to help just for any of the legal proceedings, paperwork moving forward. Jesse Hines has offered to have a second set of eyeballs on anything that John Deaton is doing. Now, given that they're in different states, I don't think that they could actually legally team up because John Deaton, I believe, is out of Rhode Island, if I'm not mistaken here. And so they've been communicating back and forth. They both agree that XRP is not a security. They have little minor discrepancies here and there. And so I find that interesting. I happen to value the opinions of both of them, and I think that they're just genuine people that are trying to get to the truth of the matter, and I find it interesting. I wanted to share a short thread where I jumped in, shared a couple thoughts, which possibly came across in a way that slightly, it wasn't some sort of horrendous train wreck, but it possibly came off in a way that I wasn't intending. My point may not have been clear. But they were talking about, one of the arguments that John Deaton has, like, is it a good argument? This is the fact that somebody doesn't know about Ripple. Is that justification for XRP? That argument, is it justification for XRP to not be labeled a security? John Deaton has said yes, and Jesse Hines actually happens to disagree with it. But again, both of them agree XRP is not a security. It's just more like, what's the best approach to go and try and prove that? And so I appreciate opinions from both of them, and I don't pretend to know what's right. I just think it's fascinating to learn from people that do this for a living. So check out. I want to highlight part of the thread that starts with John Deaton. He wrote, "If a person buys Apple stock at Schwab, they have heard of the company Apple and know they are buying stock. Many people buy XRP and never have heard of Ripple. What the SEC is claiming with our XRP is more akin to buying an iPhone from Best Buy and calling it a security of Apple." To which Jesse Hines responded. And he's out of, I think he's New Jersey. Yeah, so he's a lawyer out of New Jersey. And he wrote the following. "I mean, that metaphor really doesn't work. Knowing the company when buying on a secondary market isn't the test for a security. I own many mutual funds and I don't know half of the stocks that make them up. That doesn't make them not securities. If a person doesn't know what Ripple is, then they likely did zero research, meaning they'd invest in many stocks without knowing the company." And so if that's correct, that's fine. I'm not here to dispute John or Jesse. That's not my point here. But I did respond, and I want to share with you my two tweets and then Jesse's response to me. And then I want to just provide a little bit of clarification because I haven't had a chance to actually respond on Twitter. I've been busy lately, but I want to. Anyway, I wrote the following in response to Jesse Hines. I wrote, "Interesting perspective, but there could also be an investor in XRP who did research and bought it for informed reasons without ever knowing Ripple exists. The fact that other developers are building on top of the XRP ledger and using XRP such as Coil and XRPL Labs, for example." And so let me pause right there. That's my first tweet. So why would it not be a security of specifically of Coil or XRP Ledger? That would be one question, but then I continued on, and I want to make a broader point, actually. I wrote, "Whereas if someone is investing in Apple stock and researches it to inform themselves, there is no question that it's a security of Apple. This illustrates the point that cryptos are fundamentally different and shouldn't be shoehorned into existing archaic U.S. regulations." And so Jesse did take the time to respond to me, which I appreciate, and he wrote the following. "This doesn't make it not a security. That's the problem. The fact that you know about Ripple or buy it from Ripple is not the deciding factor. This is nothing like Apple stock. We are dealing with an alleged investment contract. and not a stock. The analogy being used isn't right. I don't know where the belief that who you buy it from and what you know about it is determinative in whether it's a security. That's the problem. That's wrong. The SEC is claiming Ripple didn't include the disclosures that you would get with a security. And so I'm not disputing anything of what he said, but I think that he may have potentially, which missed my point, it's Twitter, you got limited characters. I don't blame him. I'm not harping on him at all. Because again, I appreciate both he and John Deaton just sharing their professional opinions on this stuff. But I was getting to the point. I'm not disputing. Like, let's just say that what Jesse's stating is right. Like, it's a bad argument. That's my problem. That's exactly what my problem is. I'm not disputing whether or not Jesse's right in his stance. Let's just assume he is, which he very well may be. And that's fine. That I wasn't trying to dispute that. What I'm saying is that is the problem. If you can have a decentralized cryptocurrency where there's utility to it and you can use it and it can still be considered a security of one company, even though there's multiple developers building on top of a decentralized blockchain, as is the case with the XRP ledger, that is the problem. And so if existing law doesn't account for that, that is the point that I was making. So that's not me, again, not disputing what he or John is saying. I don't pretend to know from a legal perspective what is right. I'm just saying I have identified the problem. That's really all I was actually trying to get at there. And so that's what needs to be fixed. And I don't know how, but it's a train wreck right now. That's for damn sure. So we'll just have to hope that there's some sort of precedent that comes out of some sort of settlement from the SEC versus Ripple here. And if there is some sort of settlement, hopefully that can be used as precedent, hopefully from a legal perspective moving forward. It would add some level of clarity for the entire space, but you got to talk to the lawyers to see what's most likely or reasonable. I don't pretend to know, but I do feel like I've pretty well identified the problem here. So no, I'll go ahead and wrap it up there. Thank you very much, everybody, for your support. I very much appreciate it. And I am not a financial advisor. Do not buy or sell anything because of anything that I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.